it occurred to me when we began with the Bold ReThink was that we lacked innovation in governance. So we think that innovation is mostly technology. So the people that we think of as innovators are people like, Elon Musk or somebody like that. And we don't think about the kinds of innovations in governance that have brought about, major change. And I think of Ben Franklin, who invented the first public library or the first fire department, and he looked around for where that kind of innovation might be found. One of the things that occurred to me when I encountered John's work was, here it is. Here's the innovation. Here's an inventor who is creating the kinds of ideas for social change in governance and the law that will actually make a difference. And I love that about your work, John. And if we had a section of inventors, you would definitely be, one of the starred and featured inventors. And you've done so much in terms of voting and that basic infrastructure of democracy and what we need to actually have any kind of government that affect the will of the people, that could actually provide a just and livable future. So I'm not going to repeat your bio. I'd love to just open the floor for your thinking and thoughts for today. Thank you so much for being here.
Thank you, Carolyn. Thank you for those kind words of introduction, and thanks to all of you for joining for this conversation. I'm pleased to have the opportunity to talk with you on this subject. It's a broad subject, advancing a new jurisprudence based on the principles of political equality and American self-government, and it could certainly cover a range of subjects. I'm going to focus particularly on the subject of money and politics as it applies to that work. I actually was going to start by just sharing on a personal level how I got engaged in this work around money and politics. And it was in law school when, in fact, after having done a fair amount of work as a social justice activist in high school and college and into law school, I learned in the course of doing my third year paper about this subject of money and politics. And I learned about it because there had been a conference in Waveland, Mississippi in 1990 during the time I was in law school. And at that conference, which was put together by a group known as the Working Group on Electoral Democracy, which is founded in part by Randy Keeler, whom some of you may know, who's a celebrated longtime activist, is seen by Daniel Ellsberg as the reason why he went on to release the Pentagon Papers. He's an extraordinary human being, Randy is. And he co-founded this group, Working Group on Electoral Democracy, which was looking at the question of money in politics and what could be done around it back in the late 1980s. And they held this conference in 1990 in Waveland, Mississippi, where they brought together civil rights workers, environmental workers, civil rights, peace activists, and others from many different fields. And they wanted to have a conversation around how money and politics affected their concerns. And Dr. Gwen Patton, who has sadly passed away, she was a longtime civil rights worker in Montgomery, Alabama. She was one of the people at this conference. And Dr. Patton said at that conference, in a moment that crystallized it for so many there, she said, "We have fought and died for the right to vote. But what good is that right if we do not have candidates to vote for?" And she went on to say that getting big money out of politics is the unfinished business of the voting rights movement. And the people in that meeting decided, after she said that and further conversation, that they were going to put together a layperson's document. None of them were lawyers in that room, but they were going to put together a document, a short memorandum that outlined this idea of taking on money in politics as a voting rights issue. And they did that, and they circulated it among law professors and lawyers, and they sought to have somebody take it up as a cause. And they weren't getting any responses of anyone saying they would take it up. But because I knew Randy and I had learned about this conference, I got a hold of that memorandum as a third year law student, and I was looking for a subject for my third year law school paper that would be helpful to a broader justice movement. And so I asked Randy whether it would be helpful if I wrote my third year paper on it, and they were happy to have some kind of response that took on their issues. So I ended up spending my third year paper on this subject of money and politics as a voting rights issue. And that led ultimately to 2 law review articles that I co-authored with Jamie Raskin, at the time professor of law at American University, now, of course, member of Congress from Maryland. And these articles, which appeared in 1993 in the Yale Law and Policy Review and in 1994 in the Columbia Review, outlined this argument I'm going to share with you today on the wealth primary and how our current campaign finance system violates the Equal Protection Clause of the 14th Amendment of the Constitution. After sharing that outline, that argument, I'll also reference the work associated with a constitutional amendment or series of amendments to overturn the doctrines of corporations being treated as people and money equaling speech that the Supreme Court has enunciated in Citizens United and prior rulings. And then I'll close. The third piece of this will be around an initiative that we're very much engaged in right now, taking on foreign influence corporate spending in our elections and the opportunity we have to deal with the worst abuses of Citizens United with that kind of initiative. So first on the wealth primary argument, we, of course, commonly understand campaign finance, money and politics from a First Amendment perspective. The way it's been presented is often the issue of money equaling speech, and that those who have money have a First Amendment right to spend that money in elections. And in fact, just to give another anecdote here, early on when I was involved in starting the National Voting Rights Institute, which was the first nonprofit I started out of law school to litigate this issue around the wealth primary, there was a broadcast outside a big Democratic National Committee fundraiser in Hollywood that Steven Spielberg was hosting. It was 1996, 2 years after I had founded the National Voting Rights Institute, and there were a number of big donors attending that fundraiser for then President Clinton's reelection campaign and the Democratic National Committee. And a NBC reporter and cameraman staked themselves outside of the fundraiser to try to get people to talk about the subject of money and politics. And none of these big actors and actresses and producers, none of them wanted to talk. They're all accustomed to the bright lights. But the moment they saw the NBC truck there and the camera and the bright lights, they did not want to have anything to do with it. They scrambled away into their limos. But one actress, famous actress, did stop, Barbara Streisand, and she agreed to speak to the reporter. And she was a co-host of the fundraiser. And I'll just say that, at the National Voting Rights Institute, we were proud recipients of Streisand Foundation funding. But I do like to tell this story. So she stopped to answer a few questions. The reporter said, I want to know what you think about this process. And she said, what do you mean what I think about this process? And the reporter said, I mean, what you think about this process of people having to raise large sums of money in order to compete and run for public office. And she said, well, that's what's great about America. If you have the money, you can do whatever you want with it. And then the reporter asked the follow-up question, what about those who don't have the money? And she paused and she kind of stood back a little bit. And then she said, well, they can vote. And then that was the end of the clip. And, it was brilliant in terms of capturing the issue, because here was a big donor, again, somebody who I appreciate her politics about, but here she was saying, essentially, we can select the candidates who will be on the ballot, they can vote. We can decide what forces have influence over our politics, they can vote. We can control our policies in our government, they can vote. And really, the right to vote is far more than the right to cast that ballot on election day or via early voting or mail-in voting. The right to vote is the right to participate in the political process on an equal and meaningful basis. And what we have today is a campaign finance system that undermines and violates the right to vote by excluding voters from a critical part of the machinery for getting elected. And so this idea of the wealth primary really has two lines of cases that merge to make the argument that the campaign finance system is violative of the Equal Protection Clause, looking at this differently from the First Amendment perspective of the big money donors, but really the equal protection rights of all of us. The first line of cases deals with economic discrimination in the political process. So it's well understood that, unfortunately, that economic discrimination in many sectors of life is prohibited. There is no, constitutional right to housing. There's no constitutional right to employment. There's actually not even at the federal level a constitutional right to equal education that was decided in a case known as San Antonio v. Rodriguez that states have taken up on the issue of equal funding for schools. But there is actually in the political process a constitutional right to ensure that people are not discriminated based on their economic status. And the first case to decide that principle was the famous poll tax case in 1966, known as Harper v. Virginia Board of Elections. Now, it's important to note that by the time that case was decided by the Supreme Court, there had been two other cases that came before the Supreme Court on the poll tax. In 1937, a group of poor voters challenged the poll tax on equal protection grounds, on the grounds that it violated their constitutional rights because they couldn't afford the $1.50 it took. And they lost. The Supreme Court upheld the poll tax in 1937. And again, in 1951, a group of poor voters challenged the poll tax. And again, they lost. And each time the Supreme Court in those two cases said, well, this poll tax is necessary for ferreting out those frivolous voters. Surely, if you're a serious voter, you can come up with $1 or $1.50 it takes in order to vote. And furthermore, these states need to charge these fees in order to help pay for the cost of election. Then 1966 came the Harper v. Virginia Board of Elections, brought by a poor woman in Virginia named Annie Harper and a group of Virginia voters with her. And they were challenging the $1.50 poll tax in Virginia's state elections. By the time their case reached the Supreme Court, the 1964 amendment, 24th Amendment to the poll tax had been enacted, which banned poll taxes in all federal elections and placed it into the Constitution. But there remained 4 southern states that held on to the poll tax for their state elections, and Virginia was one of them. And so they got to the Supreme Court for the third time on this issue, and this time they won. This time the court said in Harper v. Virginia Board of Elections, a state violates the Equal Protection Clause of the 14th Amendment to the U.S. Constitution whenever it makes the affluence of the voter or payment of any fee an electoral standard. Voter qualifications, the court went on, have no relation to wealth. And there was a dissent in this ruling by those who felt that the prior ruling should have been upheld. And Justice Douglas, who spoke for the majority of the court in that case, in response to their claims that precedent should have been followed in 1937 case, 1951 case, he said this for the majority, quote, "The Equal Protection Clause is not shackled to the political theory of any particular era. In determining what lines are unconstitutionally discriminatory, we have never been confined to historic notions of equality, any more than we have restricted due process to a fixed catalog of what was at a given time deemed to be the limits of fundamental rights. Notions of what constitutes equal treatment for purposes of the Equal Protection Clause do change. And I wanted to share that because, of course, we're in this moment where we have a very conservative Supreme Court, hostile to our democracy, hostile to voting rights. But it is also the case that notions of what constitutes equal treatment under the Equal Protection Clause and notions of other constitutional rights do change. And while we at Free Speech for People have embraced the call for expanding the court and the Judiciary Act of 2021 that Senator Markey and others have introduced in the Congress to do that, add 4 more seats, we do think we have to keep fighting to advance these arguments in the courts even today. And so that's, the poll tax story. 6 years after the Harper v. Virginia Board of Elections landmark ruling came a case known as Bullock v. Carter dealing with high candidate filing fees in the state of Texas. And there, again, the court found that economic discrimination in the political process is prohibited, and that those filing fees were struck down. So you have this line of cases with the poll tax and the candidate filing fees that make clear that when it comes to discrimination based on wealth or access to wealth in the political process, that is prohibited. The second line of cases that merges to make the wealth primary unconstitutional today is the line of cases dealing with the white primaries of the past. So there will be some who argue that, well, the poll tax and the candidate filing fees, those are state-based barriers that were created by the government. Here, this is a private process that people have to go through. It has nothing to do with the government. There's no law that requires you have to raise money. You can try to run for office without any money if you want. And you can still potentially get on the ballot even if you don't have any money. So what's the problem? So that we have to look at the other issue, which is known as state action and the white primary cases. And these were a series of cases that went before the Supreme Court from the 1920s to the 1950s, leading to the last case known as Terry v. Adams in 1953, 1 year before the Brown v. Board of Education ruling. And that case, Terry v. Adams, actually dealt with a completely private process known as the Jaybird Democratic Association nominating process in the state of Texas. I say completely private from the standpoint of what we consider to be completely private, but this is the key point of that case, is that the court found that because that process, which was an all-white nominating club, nominating candidates to get on to the party primary ballot in the state of Texas, because that process was so integral for candidates to get elected, was so much a part of the machinery for that, in fact, state action was found, that they found that it did connect to the overall process for elections, and therefore they struck down that Jaybird Democratic Association's process as unconstitutional under the 14th and 15th Amendments. Now, prior to that, there had been other white primaries that had been struck down, and this was a reaction to that. The Jaybirds were trying to set up something that was an end run around those rulings. But I think it's also telling for us today that what we have in this current system with candidates raising money and big donors being the main source of those funds is that we have this exclusionary process. It's exclusionary like the white primaries of the past, this time not based on race, but based on economic status. Less than 1% of the population is giving more than 80% of all money to candidates at the federal and state level. But it's also discriminatory, like the poll tax and candidate filing fees of the past, based on economic status. If you do not have that kind of big money, you're really not going to be able to participate in the wealth primary as a voter. And certainly if you're a candidate who doesn't have access to wealthy contributors, you're not going to be able to compete in the wealth primary process. And like the white primary, it's very much integral to the overall election process. Almost invariably, You have to win the wealth primary. You have to outraise your opponent in order to go on and win election. There's certainly exceptions to that rule, but by and large, the data shows today, as it did when Jamie Raskin and I wrote these articles some years ago, that in fact, the vast majority of people first outraise and outspend their opponents before going on to win election. So that's the wealth primary argument. And while we were not able at the National Voting Rights Institute to win the cases that we brought with that argument, I think what we were able to accomplish, and I still believe in those arguments, is to establish that there's a different way of looking at this issue, that it's not just about the First Amendment rights of the donors, but there are equal protection rights and, frankly, First Amendment rights of the non-wealthy at stake as well. And I think we've also, through that time and through other work that's happened since that time, we've also recognized that this is a political equality issue. This is a voting rights issue and needs to be recognized as such. And that leads me to the next subject, which is around the constitutional amendment fight. So after the Citizens United ruling in 2010, which is how we got off the ground at Free Speech for People, we were founded on that day. Jeff Clements is the other co-founder with me of Free Speech for People. We decided we needed to get off the ground right the day they were going to issue that ruling to push for a constitutional amendment to overturn that ruling and the doctrines underlying that ruling of corporations being treated as people and money equaling speech. And that movement continues to this day. In fact, Jeff has gone on, as many of you may know, to found a group called American Promise. It's doing an enormous amount of important grassroots organizing around the country for this kind of constitutional amendment. But there are a number of amendments that have been put forward to advance this cause, including what's known as the Democracy for All Amendment pending in Congress, which we did help to draft, which has the basic principles of a political equality written into it. It would overturn the Buckley v. Vallejo decision, the 1976 ruling, which led us to the current state of unlimited campaign spending and served as the further basis for the Citizens United ruling. It would allow Congress and the states to set reasonable mandatory limits on campaign spending and help level the playing field. At Free Speech for People, in the process of doing this work, we've come to the view that we actually ought to have a stronger amendment on the table as well. And that's the Free and Fair Elections Amendment that we've authored, that you can find on our website at freespeechforpeople.org. There's a Democracy Amendments tab there where we have a series of amendments we think are needed to protect our democracy and expand it. And that's one of them. And the Free and Fair Elections Amendment would be self-executing. So rather than say to Congress and the states, you have the authority to set limits, it sets the limits in the body of the amendment directly. It sets them at $100 per contributor, either to spend or donate money, but it also requires public funding of elections. And it overturns directly the Citizens United ruling by making clear that corporations do not have political speech rights in our electoral process and may not spend their general treasury funds. So there's more on that on our website, but the amendment fight is a critical fight for broadening the conversation around money in politics and making clear that we need a constitutional grounding for this, and that the court has been wrong on this question, both in Citizens United and in the Buckley v. Vallejo ruling. And that leads to my last piece of this, and then I'd love to have a Q&A and comments and discussion. The last piece is around the foreign influence corporate spending piece, which is our major initiative right now on money in politics, in addition to our endorsement of the constitutional amendment work. And it's because we see a real avenue, even before we get to an amendment, for having this kind of an initiative succeed, both at the state level and even at the federal level. And to explain this initiative, I would start by first taking us back to when the Citizens United ruling came out. You may remember then President Obama spoke before the Congress for the State of the Union address just a few weeks after that ruling was issued. And this is a big affair, as you know. Members of Congress show up, but so do many other members of the government, including the justices from the Supreme Court. They don't always show up together, but a number of justices often appear. And they were there in the audience sitting up front when President Obama, in the course of his State of the Union address, condemned the Citizens United ruling, looking directly at them, and said that it would lead to foreign influence in our elections. And Justice Alito famously broke decorum, shook his head, and mouthed the words, "That's not true." And we now know, unfortunately, that President Obama's prediction was true, not only from the Russian government's interference in our elections in 2016, but from the fact that Citizens United opened up this loophole for foreign investors to use the corporate form to now influence our elections. 2 years after the Citizens United ruling, there was a case brought by a Canadian citizen known as Blumen v. FEC, in which this individual argued that now the corporations have the money, the right rather, to spend their general treasury funds in our elections. Why can't I, as a foreign national, spend money in elections? And he sought to strike down a longstanding law at the federal level, barring foreign nationals from spending money directly or indirectly in our elections. And he lost. He lost that case. The Supreme Court, 2 years after Citizens United, upheld that longstanding law. It's important to note that this is the only area of federal campaign finance law that applies to state and local elections as well. Foreign nationals are altogether barred from spending money directly or indirectly in any election in the United States. And none other than Judge Kavanaugh of the D.C. Circuit Court of Appeals, with whom we take issue in terms of his confirmation process. And I know Lisa Graves is on this call and joined us in taking issue with his lack of honesty in the confirmation process. And I should say Lisa, as she revealed previously, is on our legal advisory committee, and we're proud to have her as a member of that committee. But Judge Kavanaugh wrote the opinion for Blumen v. FEC in the D.C. Circuit, upholding this federal law. And he said that it was necessary to uphold basic American self-government principles. And that's what the Supreme Court upheld. They upheld Judge Kavanaugh's ruling on that question. And so there is this tension now between the Blumen v. FEC ruling and the Citizens United ruling when it comes to foreign influenced corporate spending. So what we've done at Free Speech for People is drafted model legislation that would prohibit foreign influenced corporate spending. And we're partnering now with the Center for American Progress and a number of other local partners on this. Alexandra Flores-Quilty, our campaign director on this call, is leading our campaign around this. And we've already won before the Seattle City Council our first victory with this model law. After the November 2019 election, the Seattle City Council in January 2020 passed this model law. They did so unanimously once they saw how Amazon, which of course is headquartered in Seattle, had spent $1.5 million of their general treasury funds to try to shift the makeup of the Seattle City Council. They didn't like what the Seattle City Council was doing around living wage policy, tax policy, and so they sought to change the makeup of the City Council. They fortunately lost that effort, but what they also found was that the Seattle City Council was ready to pass this law, and this law applies not just to Amazon, but to the vast majority of S&P 500 companies. It defines a foreign influence corporation as having either 1% single stock ownership from a foreign investor or 5% in the aggregate from foreign investors. Now, that may sound low, those percentages, but actually it's higher than the default position under federal law. As I mentioned, altogether, there's a 0% prohibition on foreign nationals spending money directly or indirectly in our elections. And so this is actually a compromise, 1% and 5%. But beyond that, 1% as a single stock owner is a significant investment in a Fortune 500 company. You own millions of dollars of shares of that company. You can get the CEO on the phone you can introduce a shareholder resolution with that 1% single stock ownership. And that is, recognized by many corporate law experts as a significant investment. So John Coates, who's a corporate law expert at Harvard Law School, but now on leave, he's general counsel for the Securities and Exchange Commission. He's been a proponent of this model law. He testified before the Seattle City Council for us in this. FEC Commissioner Ellen Weintraub of the Federal Election Commission is a strong proponent. She also testified before the Seattle City Council. Harvard Law Professor Lawrence Tribe supports this and has testified as well before the Seattle City Council and other bodies considering this on the constitutional viability of this. We, of course, view this as constitutional because of the Blumen case and because this is not about the principle of corruption, the appearance of corruption, as important as that is. This is about the separate principle of American self-government. So this model bill is now pending in 7 different states. We won in June of this year a second victory when the New York State Senate passed it with bipartisan support. It's been pending in the New York Assembly. While it will likely not be taken up in a special session, although we hope that might happen, it will likely get introduced again in January of next year in the new legislative session in New York, along with the Senate reintroduction of it. And we're hopeful that New York might be one of the first states to do this. In Massachusetts, just last week, we had a hearing on these bills, and there are 5 other states where this is pending. So there's real opportunity, I think, to have one or more states take the lead and follow what Seattle has done. And this is also, I should say, pending at the federal level. So Senator Warren and Congresswoman Jayapal have introduced this model bill as part of a broad anti-corruption package they have. And Congressman Raskin is working closely with us in introducing this as a standalone bill. And I think what this has the opportunity to do is really take on, as I said, the worst abuses of the Citizens United ruling. Our partner at the Center for American Progress has done a survey and found that this would actually implicate 98% of the S&P 500 companies, which are, by these threshold definitions, foreign influence corporate spenders. And of course, they don't have to participate in spending money elections, and then they won't be affected by this law. But if they seek to do so under this law, they would now be prohibited from doing so. So I'll stop there in terms of the presentation. What I'd like to do is close it out with just a short video on this new initiative around foreign influence corporate spending and what we're doing on it, which Alexandra will queue up, and then I'd welcome a conversation, discussion on any of this. Thank you. And the real challenge I think we face today with our democracy is that big money interests are drowning out the voices of ordinary citizens. The threats of super PAC spending and of foreign corporate money are at the doorstep of St. Petersburg. And St. Petersburg has the opportunity to protect and defend its democracy here with this proposed ordinance, and to set an example for the nation of what we can do to reclaim our democracy.
Massachusetts currently has a bill pending in the Massachusetts State Senate that we worked on with Common Cause Massachusetts. Obviously, the premise of this law is not xenophobia. It's not to discourage foreign investment. What it's to do is to ensure democratic self-government.
The fear is, and the danger, the real danger is, that someone like me might fall prey to big money able to come in and solve my campaign spending woes with large checks. But those large checks would absolutely come with some spoken or unspoken deliverable.
Why so much interest on the part of these super PACs, the corporations that are funding them, for the outcome of these Seattle City Council elections?
Well, it was a remarkable pace of corporate political spending in Seattle that outstripped anything that had been seen before. And a lot of it was driven by Amazon.
Here, the issue is not the threat, it's here and now. Seattle is already experiencing this flood with respect to the corrupting influence of big money into super PACs and with respect to foreign influenced corporate spending.
Our U.S. Constitution is very clear that our government should be governed by the people of this country, and it is fundamentally about preserving our democratic process and protecting our Constitution.
But corporations that are foreign influenced aren't just a collection of citizens. They are a collection of potentially citizens, non-citizens, foreign governments. And so with regard to political spending, the rights that flow to citizens don't necessarily flow to foreign actors.
So in Maine right now, we are facing the Central Maine Power Corridor, but it's owned by Iberdrola, which is a Spanish company whose major investors aren't even from Spain. And they are dumping huge amounts of money, like just ridiculous amounts of money.
We're talking about corporations that are, ultimately deriving their money and are being run in the interests of, to varying degrees, foreign investors. And what that means is that, the views of ordinary Maine citizens are really getting relegated to sort of pawns in this larger battle between corporate interests.
There are many other things that have to happen to reform our system of big money in elections, but this is a critical way for the American people to fight back and reclaim our democracy. Thank you, Alexander, for showing that, and I'm happy to open it up now.
I see Lisa Graves' hand up, but I first want to recognize her for being the co-leader of Bold ReThink and one of the most dedicated people for justice. And so over to you, Lisa.
Oh, that's very generous of you, Carolyn. I just want to say, John, I am so grateful for your generosity in taking the time to meet with us amid so many things you're doing to fight on a daily basis for democracy. You are truly the person I most admire in the whole wide world on analysis of these issues and your strategy, the strategy that you deploy. And so I just wanted to thank you so much. One of my only regrets is not having the chance to work with you more often, and I would love to do so and try to make sure to carve out, additional time to help support your brilliant, genuinely brilliant efforts and the team that you have built up to really take these actions both nationally and in the state. So I'll leave the questions to the rest of the folks here. I just wanted to say from the bottom of my heart, really, we are so lucky to have a warrior like you fighting for our democracy with such intellect and such great heart in this crisis that we're in. So from the bottom of my heart, thank you, John.
Lisa, thank you. That's so kind. Right back at you. We're so honored to have you on our advisory committee. I fully agree. I hope we can work more together, but I have such admiration for all that you do. Thank you so much for saying that.
Any questions or thoughts that you'd like to raise after you've heard this?
Yes, actually, I'm excited about the Seattle ordinance and the 1% foreign investment in the company. I'm wondering what portion of U.S. corporations that applies to, if you have any data on that.
Yeah, no, so thank you, Sanford, for the question. We haven't done the analysis of all, corporations, what percentage, but as I said, our partner at Center for American Progress has done a survey of the S&P 500, and it would apply to 98% of the S&P 500. And just to give a few other examples beyond Amazon, Uber has a 5% stock ownership by the Saudi government, Saudi Kingdom, and they have a seat on the board of directors of Uber. And of course, Uber is very engaged in spending its general treasury funds in elections around the country and trying to actually buy policy outcomes via the ballot measure process, including in California, Prop 22, and now in Massachusetts. Airbnb is another good example of significant investment from a Russian oligarch venture fund. There are others like that. So we have not had the opportunity yet to canvass all U.S. corporations, but certainly among the very top ones, the multinational actors in the S&P 500, it would cover the vast majority of them.
Just a follow-up idea is I'd encourage you to think if there's any way that progressive shareholders could support this campaign around this. So for instance, what I do is I write shareholder proposals and defend them, right? Yeah. So I'm thinking about, a proposal that asks companies to, alerts companies to these new laws that are coming, that they should get ahead of it and get out of spending in politics, et cetera, something like that.
Yeah, that's brilliant. That's brilliant. We'd love to work with you on that. That's great.
So be in touch I have various clients I can think of who'd be interested in that.
Excellent. That's great.
Okay.
That's great. Thank you.
Good.
Yeah, I was going to introduce Sanford to you as one of the primo lawyers, maybe the primo lawyer, drafting shareholder resolutions on the side of the angels and justice.
I'm actually aware of Sanford's great work on this, but I appreciate the recommendation, Sanford, and I think it's a great idea, and we'll follow up. Yeah.
Joe, you need to take yourself off mute.
Thank you. Well, John, it was a really great presentation, and I really want to congratulate you on the success you're having in getting some of these ideas actually adopted. And I don't follow this super closely, but I think I understand that one of the issues in the Supreme Court's looking at these issues in money and politics is that they just haven't accepted the link, which seems painfully obvious, between political contributions and the quid pro quo that I think was mentioned in your in the video a few times. And that, I mean, it's just so obvious that that's what's going on, right? But they didn't accept that. And they said, I think, in Citizens United, well, transparency, is the antidote for that. So, to get the court to accept this contract, they're going to have to accept, aren't they, that link somehow. And it's an evidentiary problem that's kind of a big one, right? Even though it's obvious. So anyway, I just want to ask you what you think about that.
Yeah, no, I really appreciate you highlighting that, Joe, because it does get to the core of what the focus of this initiative is. So you're right that the Citizens United ruling really narrows even further the scrutiny in the campaign finance sphere when it comes to restrictions on money in politics, and that they have to be justified by the governmental interest in preventing corruption or the appearance of corruption, with the exception of foreign nationals. So there's one now newer area, a new interest that the court has recognized as well, which was Judge Kavanaugh's interest that he articulated of American self-government that is separate and distinct from the corruption interest. Now, certainly our work with the wealth primary fights during the National Voting Rights Institute, and something that I continue to believe in, I'm pretty confident Jamie Raskin continues to believe in, is that there ought to be another interest that's established, which is around political equality and leveling the playing field. We have a ways to go, obviously, to get a Supreme Court to accept that argument. But in terms of this current court, given that Judge Kavanaugh is now Justice Kavanaugh, given that they upheld, after Citizens United in Bloom v. FEC, Judge Kavanaugh's opinion, what we would argue is that the focus does not need to be on whether this foreign investor is corrupting the process, but merely whether the foreign investor has any say whatsoever in the process.
I gotcha. Okay.
And that's the argument that we're going to be advancing. If we
gotcha. Yeah. Can I ask you a quick follow-up? Would this argument also apply to, let's say, individuals, super wealthy individuals? I'm sure they own a lot of foreign stock and investment also, somebody like Jeff Bezos. I mean, I don't know.
Yeah.
I guess mostly Amazon, but who knows,
Well, so right now, I would say the federal law already applies to them. So the federal law that was upheld in the Bloom v. FEC ruling bars foreign nationals from spending money directly or indirectly in any election. And so if you're doing it from an individual perspective with your own individual money, you're already barred if you are a foreign national. But if you're trying to do it through the corporate form, that's the loophole that was created by Citizens United that President Obama condemned, that Justice Alito said was not true. That's what this loophole is facing with respect to this law. We're trying to close that.
Gotcha. Thank you.
Mary Beth, you had a question that you put in the chat. Would you like to ask it yourself directly?
Okay. Thanks for I didn't want to take up time, but hello, John. And how does this effort compare to the Anti-Corruption Act, which seems to be stalled? I know one advantage your act has is that getting foreign money out of our elections is a whole lot easier sell on a bipartisan basis than getting big money in general out of elections. But are there other comparisons that we could point to?
Well, thank you, Mary Beth. I think you're right that's the opportunity here that unfortunately we don't have in a bipartisan way, at least at the federal level, with some other reforms. We know, for example, that the new Freedom to Vote Act that Joe Manchin was behind, among others, putting forward, eliminated the public funding provisions that had been in the For the People Act, despite, frankly, I should say, widespread polling that shows the public across the political spectrum supports public funding of elections, supports leveling the playing field, supports a constitutional amendment to overturn Citizens United and Buckley. So among the populace, there's strong support across the political spectrum. But in Congress, you're right that these other efforts to deal systemically with big money in politics are stalled. This particular piece of legislation, which again, Congressman Raskin is soon going to introduce as a standalone bill, I think does have the opportunity to have bipartisan support, just as we had 6 Republicans in the New York State Senate vote for it. And that is because of the argument that we shouldn't have any foreign influence in our elections. So that's the hope. I think having one or more states advance this and help show the way will propel the discussion in the Congress on this. But there's already, I think, a fair amount of interest even after the Seattle victory. And of course, Congresswoman Jayapal is from the Seattle area, and I think that's partly why it ended up in that bill.
The effort called Represent Us, which is a national lobbying effort, legislative advocacy, kind of city by city. Yes. Do you have any idea how they're doing on this front?
Well, I haven't checked back with them more recently, but I know they've had successes at the state and local level on key reforms, both ethics reform, and they certainly were helpful in backing the democracy voucher program that Seattle voters passed, which is a form of public funding of elections in Seattle. So I think those efforts at the state and local level to use the ballot measure where there is that availability, not every state has it, to advance these kinds of policies is a good way to go. Because often, unfortunately, when you're talking about reform in this area, you're talking about competition for incumbents, right? I mean, when you level the playing field, when you create public funding of elections, when you even frankly limit overall spending, that's going to create a scenario where the challengers maybe have more of an opportunity to have equal competition with the incumbents. So having a ballot measure is a way to get around that, obviously, when you can't get incumbents in the legislative process to support it. That being said, there are many legislators I know all across the country who support these kinds of reforms, and they are tired of the fundraising. They're tired of the influence that money in politics has on the policies they're trying to enact. And so there are a lot of allies in the legislatures as well.
I think there are also a lot of political donors that are tired of being hit up constantly. And it's gotten to the point where you feel like you have to pay people to do their jobs.
Yes, I agree fully. There's a lot of donor fatigue there too.
Gil,
and they also are asked to spend money on both sides to maintain their influence.
Gil, you had asked a question. Do you want to raise it yourself? And Gil has an interesting relationship to many of the big businesses who are thinking in some ways about sustainability. So, and he's worked for government himself. So curious to hear what you want to raise, Gil.
Yeah, local and state government, and I advise corporates on climate strategies, and so I'm straddling these two worlds of where they are progressive and where they are not. It's an interesting dance. Question is very quick, and I'm going to have to leave at the top of the hour for another call. But John, first of all, thank you for all the work you're doing. It's impressive and incredible and deeply needed. What can civilians like us, not a lawyer, not an elected, what can civilians like us do to help further this work?
Thank you, Gil, for that question. So we would love help, in particular, with this new initiative around foreign influence corporate spending. If, for example, you're in one of the states where this is already pending, and if you go to our website, you can learn about those states. We would love your help in connecting us with others in your state who might want to participate in lobbying state legislators on this question. And if you're not in one of those states, but you have ideas in your community, either in your own city or in your own, state legislature where there might be new champions we could reach out to, we'd welcome that as well. And, again, on our website, you can find a fair amount of material, but we're happy to follow up with you directly if you have ideas of how we can connect.
Well, just a hint, I'm on your website and I don't see where to find what states you're active in. I'm in California. What's the status here?
Well, actually, so California, it's not yet up on the site. And I should say, when you go to the website, if you go to Money and Politics, there's a drop down link to the challenging foreign influence in elections right up at the top there. But California, we are going to have a champion introduce our bill for the next session in January. And there will be a campaign in the state to get legislators to co-sponsor it. So we'd welcome your help on that.
Can you say who the champion is?
Yes, Assembly Member Alex Lee.
Okay.
And he's a younger, newer member of the Assembly.
Okay, and any efforts at the municipal level in California?
Well, we've been trying in Los Angeles in particular, but we welcome on that front ideas of municipal champions.
Do you have anything like a template, a one-sheet sample legislation that I could bring to my city council members?
What we could do is certainly provide you with a one-sheet description of the bill. What we've done whenever there's been interest by a city council member or state legislator, we've actually participated in helping to draft the bill. Our partner in California is Money Out Voters In, which is a volunteer group based in Los Angeles area, and they also, I think, would be very interested in working with any new ideas you could bring to us.
Yeah, I'm in Berkeley, California. Berkeley has a history of liking to be first.
Yes.
On legislation. So I'll put my email in the chat.
Great.
And love it if you'd send me some stuff.
That's great, Gil. Thank you. We welcome that. Thank you so much.
You bet.
So we are at the top of the hour, and I'm just going to check in. We have one more minute. Is there a last question? Well, what an honor to have you with us, and with your team and all of these fabulous people who came to join us. It's like the dragonfly's eye that's so multifaceted, and that's how the dragonfly actually sees what's really there. And what a treat to have you with us, John. And
thank you, Carolyn. Thank you so much. I really enjoyed it. I saw that Jeannie did put her hand up, but I don't know if she wants to.
Oh, did Jeannie put her hand up? Oh,
I was only clapping for all of your awesome.
Oh, I see. I misunderstood that. Okay. Thank you. That's kind. Thank you. I really enjoyed it. Thank you for inviting me, and thank you for all the work that all of you do.
Thank you. And thank you all for being here today. We'll stay tuned for next month. Thank you.
All right. Take care now.
Bye.